Defender Lauren Tierney on behalf of Mr. Dico. Mr. Dico, please state your name for the record.
Ahmed Dico.
Sir, can you state your name?
Yeah, Ahmed Dico. Can you hear me? Hello?
Can't hear you. We might have to have Mr. Simon fix it.
Can you hear me? Hello?
Hello? Hello? We can barely hear you.
Can you hear me now?
Yes, I can hear you now.
Okay, Ahmed Dico.
All right. Go ahead.
We're here for a show cause hearing. Mr. Dico informed me that he is unable to make substantial payments as he's unemployed. However, he is looking for work and is able to make $15 payments at this time.
15
15.
per month or what?
Yes.
I believe per month. Is that correct, Mr. Dico?
Yes.
All right, what I'll indicate is $15 per month. Beginning May 5th, May 16th, 2025. Give me a review date. Do we have it?
I just. September 10th.
I'll set a review on this for September 10th, 2025, 9 a.m. Thank you.
Thank you.
Case People versus Muhammad Farah.
Good afternoon, Public Defender Lauren Tierney on behalf of Mr. Farha.
He's on, but Muhammad Farah.
Yes, hi, I'm sorry. I have to unmute myself. I'm sorry.
This is a show cause. I have him on $825. When is that gonna get paid?
Is, Your Honor, Mr. Farha did come here in person earlier today, and we did have a chance to speak. He's asking that the court consider waiving any amount of the balance. There is, for example, some, I think a couple $100 of probationary oversight fees. He ended up doing the 93 days on this piece. So he's asking for your consideration.
Maybe at some point I'll consider that, but when is he gonna get this paid?
Well, he is back to work. Mr. Farha, how much do you think you can pay on this case?
I honestly just literally started working like this week, honestly, and I've been dealing with child support too. So like I'm trying my best. I'm really trying my best, and I didn't even know about.
I'm gonna adjourn this out to July 9th, 2025, 9 a.m. He's to come up with a payment plan for me to start making payments on this.
Okay, is there anything you could do on the balance? I mean, to bring it down a little
Well,
bit.
you're gonna have, I'll take a look at it, but you gotta start paying on something, and then I can take a look at the balance, but I'm not gonna start out there.
Okay, all right, no problem.
Thank you.
All right, thank you.
Court calls the case, People versus Shirley Hartford. Shirley. Who's that? Shirley Hartford. Not here. I went on about 400. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. $5,000. I'll give a 10% privilege. That warrant will issue immediately. Case People versus Donald Holloway. Donald Holloway. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. I'll give a 10% privilege on it. That warrant will issue immediately. Court calls are both on. Cases of the people versus Alexander Hunter.
Good afternoon, this is Public Defender Lauren Perry on behalf of Mr. Hunter. I did not have contact with Mr. Hunter today prior to today when I have the Zoom. If not, I have no explanation for his failure to appear, and I would request an adjournment of the show cause hearing.
Bench warrant will issue for defendant's failure to appear, bond 5,000. I'll give a 10% privilege on each case. Those warrants will issue immediately. Court does call the case of the people versus Nathaniel Laurent.
Good afternoon.
Good morning, Your Honor.
Lauren Perry on behalf of Mr. Laurent. Mr. Laurent, please state your name for the record.
Nathaniel Laurent.
All right.
We're here for a show cause hearing. I don't have in my notes what Mr. Laurent can pay moving forward. I would ask for him to inform the court what he thinks he can pay. Mr. Laurent, your balance is about $1,100 on this case.
Okay. I would ask, maybe can I request like a bi-weekly payment of like $100 so I can try to get started on it? Basically the only
Every
reason why
$100 every 2 weeks.
Yeah, I can try to aim for that because I need to start paying it. Like I just been set back with my
Yes,
health.
you do.
I just been set back with my health lately, and it's just
Okay.
scary with my health
All right.
and trying to pay this stuff so I can get everything behind me.
All right. I'll order $100 every 2 weeks. When are we going to begin that?
Can I do 2 weeks from now?
Sure.
Okay.
It is, I'll make, say starting May 16th.
Okay, thank you.
You're welcome. All right, you're all set. Thank you. Court calls the case, people versus Evan LeBron.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. LeBron. I did not have contact with Mr. LeBron prior to today. I have no explanation for his failure to appear, and I would ask for an adjournment of the show cause hearing.
LeBron. No response. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $5,000. I'll give a 10% privilege. That warrant will issue immediately. Court calls case of the people versus Keith Malone.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Malone. I have not had contact with Mr. Malone. Present or on Zoom. I have no explanation for the here, but that's for an adjournment of the show cause.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of 5,000. Give a 10% privilege on that. That warrant will issue immediately. Court does call the case of the people versus Bridget Martin. Bridget Martin. No response. 5,000. 10% privilege on that immediately. Court calls the case of the people versus Thomas Mills.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Mills. Seems like Ms. Pate did try to contact him, did not have contact. We have no explanation for his failure to appear. I would ask for an adjournment of the show cause here.
Mills, no response. Bench warrant 5,000. 10%. Warrant will issue immediately. Court calls case people versus Lee Parker.
Assistant Public Defender Lauren Perry on behalf of Mr. Parker. Again, Ms. Pate tried to have contact with him, was unable to do so. We have no explanation for his failure to appear and would ask for an adjournment of the show cause.
Bench warrant 5,000. Give a 10% privilege on it. Warrant will issue immediately. Court calls the case People versus Savantre Scott.
Assistant Public Defender Lauren Perny on behalf of Mr. Scott. We did have contact with Mr. Scott. We're unable to make contact. We'd ask for an adjournment of the show cause.
Bench warrant will issue for defendant's failure to appear. Bond will be set around $7,500, 10%. That warrant will issue immediately. Case of People versus Legarian Thomas.
Assistant Public Defender Lauren Perny on behalf of Mr. Thomas. We have not had contact with Mr. Thomas. We don't have any explanation for his failure to appear. We'll ask for an adjournment.
Let's check one thing on here. Bench warrant will issue for defendant's failure here. Bond in this case will be set in the amount of $10,000. Give a 10% privilege on that. Warrant will issue immediately. Let's call the case of the People versus Hamad Tomlin.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Tomlin. We've not had contact with Mr. Tomlin. We ask for an adjournment of the show cause.
Bench warrant will issue for defendant's failure to appear. Bonds will be set in each case in the amount of $5,000, 10%. That warrant will issue immediately. Court does call the cases of the People versus DeMarcus Washington.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Washington. Mr. Washington will be on Zoom. Your Honor, Mr. Washington's been here multiple times for these cases. He informed me that he received a letter that his taxes will be garnished for these amounts. He was recently sentenced to 12 months probation for resisting and obstructing case. He says that he needs more time to pay. I did have contact with him. I'm not sure why he's not here today. I would ask for an adjournment.
Bench warrant will issue for defendant's failure to appear in these matters. Bond will be set in the amount of $5,000, so give a 10% privilege on it. Those warrants will issue immediately. Court does call the case of the People versus Jacob Undergrove. No counsel. Undergrove. No response. Bench warrant will issue for the defendant's failure to appear. Bond is set in the amount of $5,000. 10%. That warrant will issue immediately.
Yes.
All right, that ends that block. Court stands in recess. Now, hold on a minute. Everybody can be seated. I'm sorry, that's my bad. I should have told you.
All rise. 14A District Court, County of Washington, State of Michigan is now back in session. The Honorable Judge Simpson for that.
You may be seated. Brought someone to help me out. So if it doesn't go right, her fault. Court does call the case of the People versus, is it Rogaya Alasi? I probably messed that all up.
It's Kyle Burdell on behalf of Rogaya Alasi. Good afternoon.
What I said.
Pretty good. Yeah, close enough for a town of this size.
Go ahead.
Your Honor, so we are here for sentencing. I'm sorry, please state your name for the record. Ms. Alasi.
Rogaya Alasi.
Your Honor, so we are here for sentencing today. I have reviewed the recommendation from Agent Pilar. I would like to add a few things on behalf of my client. She has already, the recommendations include CCOP and VIP. Those have already been completed at this time. So she's already done that. She's already well on her way to completing her terms of probation. Your Honor, we do ask that the court follow the recommendation from probation. I've spoken on her behalf and I've allocated on her behalf previously, but she is, a hardworking single mother. She's working on getting and staying sober. She's had no violations on the scram tether for several months now, I believe, since we were here, I believe in January or February. So she's been no issues with that. Her mother, who's in the courtroom and attends every time I meet with Miss Alasi, and every time she comes to the courtroom, her mother's present and very keen on helping her with her sobriety. That is a very important part of their culture as well, as staying sober. So that is something that'll, I'm confident that she will be able to stay sober. She wants to go to school for nursing. And she's a very hardworking single mother. She's got a 5-year-old son who she's raising without assistance from his father, the young man's father. So, Your Honor, at this time, we are just asking that the court sentence her pursuant to the probation recommendation. She is currently on tether. The report is silent as to it due to, her taking accountability and all the hard work she's already done. The fact that she's already gotten a head start on the terms of her probation.
Means it comes off, Mr. Verdell, but if you want me to consider keeping it on, I will.
Your Honor, I'll be done talking now.
Okay, good.
And Teresa Blair on behalf of probation. Your Honor, I just wanted to update the court. I did get verification that she did recently complete the CCOP program. So I do have verification that that is done. As to this grant, probation has no objection to that coming off, given that she has completed the programming component and she has to report today.
Lady, anything you want to tell?
Yeah, there is. I first off do want to sincerely apologize for my wrongdoing in the past. I am, though, very thankful that all this happened because I do consider it a blessing in disguise because I could have been in a way worse place. And I'm very thankful that it was only me that got injured in the accident too, because the victim panel video actually did affect me a lot. I'm just glad I didn't hurt nobody else the way that person did. And I would never want to put myself or anyone in that predicament ever again. And I'm working on staying sober and yeah, I'm done. I wanted to thank you.
It's okay. I'm just watching your mom. She's listening to you.
It's really important in our religion, so it's a big thing for her.
Oh, I'm sure it is.
Yeah.
I also noticed your reaction when Mr. Verdell said your mother's been here every time and you kind of had to wipe your eyes, right? But it's a funny thing because no matter what you do, she never left you, right?
Yep.
She stood by you and wanted to show you that although you didn't do the right thing,
that I'm better than and I'm capable of doing the right thing.
yeah.
Yeah.
All right. Anything else you want to tell?
No, I'm just very thankful. Honestly, I really am. I have a lot of gratitude towards the whole situation.
Blessings come in different ways.
Yeah, they sure do.
The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. Particularly, the alcohol screening assessment identifies the benefit of outpatient treatment, AA meeting attendance, and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change for is a man to monitor the compliance of recommended treatment. It is therefore the sentence of the court that will place you on 12 months probation. You're to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. When can you pay that?
I'm gonna need some time, but I will work on a payment plan though, on see how I could.
How much do you have anything today?
No, I do not. Not today,
All right.
but I am working. I have a stable job.
You'll be set up on a payment plan as arranged by probation. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the CCOP program, but you have completed that at this point. Correct. You're to attend one AA meeting per week with monthly verification to probation. You're to provide proof of victim's impact on attendance to probation. All order 93 days in jail, credit 14 days. The balance is suspended. Thank you.
Judge.
Mom, thank you for coming with her.
Thank you.
You're welcome.
Working together, take up the good boy, Kesha. Thank you so much.
Okay. All right. Take care. Court does call the case of the people versus Christopher Miller.
On behalf of, but not with, Christopher Miller, standing in for attorney of record Ed Drugas. I have
Mr. Miller. Christopher Miller.
He is not judged. I have no explanation for his absence, nor has Mr. Drugas had any recent contact with him.
Teresa Claire on behalf of probation. Your Honor, Mr. Miller failed to complete or set up an appointment for his PSI of the probation office. He also failed to comply with testing at community corrections. This court did issue a bench warrant in this case already due to his bond violation. Given that he's not here, probation just asked that the bench warrant continue.
What was it? Was it a no bond?
Well, just 1 second, Your Honor, I can tell you, I believe so.
I believe it was a remand, Judge, yes.
I will leave the current bench.
That's correct.
Yes.
Bench warrant out. I'll leave the current bench warrant out.
Just like, Judge.
Thank you. Court calls the case of the people versus Douglas Hurd.
Hello, Your Honor, Murray Duncan, appearing on behalf of Douglas Hurd, who is to my right.
Sir, state your name.
Douglas William Hurd Jr.
All right. Go ahead.
Judge, we had a chance to go over the pre-sentence report. We do find it to be factually correct. I've known Mr. Hurd for quite some time. I was baffled that he would take off after he had the accident. What's going on with Mr. Hurd is in November of last year, he started having issues with breathing, and he was being treated for that at the VA. And when he got in the accident, I don't know if he panicked or what. The accident was not caused by anything with his breathing. He just wasn't paying attention and he had a car from behind. But after that happened, he started having trouble breathing, and he had breathing inhalers at home, and he left because he thought he needed them. He went to the VA the day after. And since then, he's been at the VA numerous times. He spent 8 nights at the VA hospital last week, and he got out. And luckily now they think they have a handle on everything. He's got numerous issues. He's got some heart issues, but he's on the proper medication now, Judge. And he knows he made a mistake. There was no reason to leave. He doesn't have a warrant. He wasn't in trouble. There was none of the obvious reasons. And he was there long enough where it was obvious that everybody would see his license plate and see him. So it wasn't any surprise when they discovered that it was him. He's sorry, and he's hoping that the court adopts a recommendation.
Mr. Hurd, anything you want to tell him?
I'm sorry for what I did, and I learned I better just stay there.
What branch of the military?
I was in the Army.
Army. Did I ask you that before?
No, Your Honor.
All right. How many years?
I was in there for 3.5 years. I was in the first Gulf War.
God bless you. Well, I know I'm about to sentence you, but I'll just say, and it sounds trite, whatever to say it, but I thank you for your service.
Thank you, Your Honor.
I realize it's people like you, despite anything that you do, it's people like you that were willing to serve that allow me to do what I get to do every day. So thank you.
Thank you, Your Honor. Sentence
of the court, fines and costs of $400, $500 restitution to DC due payable through the court. When can you pay that, sir?
I'll pay it today.
Thank you. Pay that today out at the counter. And then I'll order 90 days in jail that is suspended.
Thank you, Judge.
Thank you.
Have a great afternoon.
Thank you.
You do the same. Court calls case People versus Deanna Aleneski. I messed up that name entirely.
Good afternoon, Your Honor. Sam Bennett appearing on behalf of Miss Golembeski.
Is she here?
She is. Miss Golembeski, can you state your name, please? She's on the screen.
Yes, Deanna Golembeski, am I not showing up yet?
No, your video's not on.
Oh, you're not.
Oh, that's cool. Maybe it's just taking a minute.
I'm not sure why the video isn't working.
I know, I've got it, like I took the red line off it. I clicked it. Let's see.
Judge, I do know that is Miss Golembeski. If we can do it without the video.
If you're on your representation, I'm not going to have a problem with that.
Okay, thank you. That's definitely her. And Your Honor, we are here for the pre-sentence report. It's factually accurate. No additions, corrections, or deletions. There she is. Your Honor, I would just ask that you follow the recommendation. Only request I would have would consider reducing community service a little bit as she works 40, 50. Other than that, I think the recommendation is fair. Thank
you. All right. Ma'am, is there anything you want to tell me before I impose sentence?
Just that I just want to say that I have never been in trouble before, and it was a bad mistake, and I'm sorry that it ever happened. And since I have been to other grocery stores and taken extra time on my day to go to the checkouts that they checked out, and funny, not funny, say I have PTSD about self-checkouts.
To sentence of the court, I'll place you on 4 months prosecutor deferred sentence. You're to pay $480 fines and costs, $120 probation oversight fees. When can you pay that?
Can you go online to pay it?
I'm sorry?
Can you go online to pay it?
Yes.
Okay, I will try to go online to pay it today. If not, I will try to get it.
Okay, you might want to wait until Friday, make sure it's entered in the system, but just get it paid, okay?
Okay, and I for sure will get it paid by Monday.
All right.
That's okay.
And you can use the QR code that's on the screen if you know how to use a QR code. That'll take you right to the payment site.
Okay, so then I click on open up this whole thing again, like on Monday, or?
Well, or you can take a picture of the QR code, or you can scan the QR code while you're on there, however you want to do that. Okay, or you can call the court.
Okay.
Okay. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random screens as requested by probation. You are to complete a theft class within 60 days. I am going to order the 25 hours of community service as directed by probation. No going to any Walmart in the state of Michigan.
All right. 14A District Court for County of Washington, State of Michigan is now in session. For the court here, the Honorable Judge Simpson.
You may be seated. Could we have the waiver?
Of course, Your Honor. Good morning, Ashley Lonnie for the people. Your Honor, this time the vote waiting for this honorable court in the Office of Public Defender. People do not believe that any conflict exists. They are the voice called out.
Ms. Pate.
Good morning, Your Honors. Public Defender Natalie Pate on behalf of the Public Defender's Office. Likewise, Your Honor, our office does not believe that conflict exists between our office and this honorable court, but if one to wherefore arise, we would waive such conflict.
The court for its part, thank you. The court for its part also does not believe there's conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the People versus Derek Hall. All right.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Hall, who appears via Zoom from the Macomb County Jail. Sir, can you please state your name for the record?
Here, Dwayne Hall.
All right.
Thank you, Your Honor. Today's the date and time set for sentencing this matter. I have received and reviewed the PSIR as well as the recommendation this week. However, since I did receive that, I had not been able to have an in-person visit at the Macomb County Jail with Mr. Hall. I will state for the record that the sentencing recommendation is for time served as well as the statutory minimum fees. So I will leave it up to Mr. Hall. Is it whether he would like to proceed today and ask the court to adopt that recommendation, or if he would like to adjourn the sentencing so I can meet with him now that I have the PSI. So Mr. Hall, this is the 2019 case that you pled to, and the sentencing recommendation is for time served. I got just that report this week. We can adjourn your sentencing out so I can come down and meet with you and discuss it unless you were comfortable proceeding today, understanding what the recommendation is.
Time served?
Yeah, the sentence I would impose are the statutory minimum fines and then the credit.
What's the fines?
For time served.
What's the fines?
It's on count one, it would be $125 and the other would be $50. There's nothing I could do about that. Those are set statutory minimums.
Is there any way I could do community service for those? On release?
You could, but you'd petition the court, but we're not going to really do anything with those, quite frankly.
Okay, so can I ask my lawyer a question about this habeas corpus that I had sent in? It was saying basically y'all had to get back with me within 10 days or dismiss it. Is that?
So Mr. Hall, I believe that's about a different case. Yes, Your Honor, that that might be for a different case, but maybe for this case, if we request an adjournment.
That's for this case. I sent in a habeas corpus, one habeas corpus for both of those.
I don't want you and your attorney to have discussions publicly this way. If you want me to adjourn your sentencing, I will adjourn it and we'll set it for another day.
Okay.
Or we can proceed today. It's up to you.
I mean, it's going to be the same charge, so I'll adjourn it to see if see what else can I do. Do not have to pay that fine because I don't have it, and right now, even if I was once I got out, I've been homeless for like the last 8 years, so it's like so.
So Mr. Hall, sorry, Mr. Hall, I don't mean to interrupt, but we can adjourn it so I can have a discussion with you, just so you know the recommendation won't change, but we can absolutely discuss it so we can have a private conversation. So the judge did say he would adjourn it for us.
Yes, ma'am. Thank you.
You want it adjourned?
Yes, sir.
Okay.
Thank you very much, Your Honor.
I'll adjourn this sentencing to May 14th, 2025, 9 a.m.
Okay, thank you. God bless you. Have a good day.
Thank you, Mr. Hall. I'll be down to see you, okay?
Okay.
Thank you.
Court calls the case, People versus Jacob Spelling.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Spellings. Please state your name.
Jacob Spellings.
All right.
Your Honor, today's the date and time set for bench trial. We have come to a resolution. Mr. Spellings will be pleading guilty to an added count, I think it would be 3, of operating while visibly impaired. And in exchange, counts 1 and 2 would be dismissed.
And that would be a first offense, Your Honor. OWVI first offense, the 93-day misdemeanor, $200 fine, and various license sanctions contrary to 257-6256B as a boy.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
State your name.
Jacob Spellings.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while visibly impaired. Is that correct? Or operating while impaired or visibly impaired?
Visibly impaired.
Okay. Operating while visibly impaired. Is that correct?
Yes, sir.
All right. That is a misdemeanor punishable by up to 93 days of jail, up to a $300 fine plus court costs. The court could also order community service and any rehabilitative services the court deems necessary. Court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services.
Yes, sir.
Understand that, sir?
Yes, sir.
All right. And understanding that, you still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty, sir.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, sir.
All right, you signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights in there for.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
I'm on probation, but this incident happened before I got on.
Before you got on probation.
Yes,
All right.
sir.
Has anybody promised you anything other than what's been stated here today to get you to plea?
No.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
Yes, sir. I think.
And of your own free will?
Yes, sir.
And because you believe that you're indeed guilty of this offense?
Yes, sir.
November 13, 2023, at the location of Platte Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you ingested a controlled substance or an intoxicating substance, I should say?
I don't know how to answer that, sir.
Did you smoke marijuana?
No, I didn't. I didn't.
Did you ingest marijuana in some way?
No, but I had a very small amount in my system from the day before. And also I was on medications from a doctor prescribed that I didn't know would affect my driving. So I guess, yeah, I was impaired.
Well, all right. So you took certain prescribed medications?
Yeah, they were given to me at the rehab the last time I went, and they never told me I couldn't drive on it.
Hold on. So, what kind of medication was
it? They were antipsychotics and nerve pain relievers.
Okay, it was a controlled substance, correct?
I don't think they were controlled. I don't think they're controlled substances.
So
wait. No,
you can't buy them.
I think one of them was. Gabapentin.
Okay. Yeah. And you had also, at some point prior to your driving, smoked marijuana or taken some type of.
I did not smoke marijuana while I was driving. No.
But prior to driving.
Did you listen to my question?
Prior to driving, I did not smoke marijuana. No.
I thought you said you did the day before.
The day before. That's not that day, though. I'm sorry, I'm not understanding, sir. I apologize.
Okay, so
I apologize.
Prior to your driving, that would be any point prior to your driving, you had smoked marijuana.
The day before, while I wasn't driving.
Okay, and the day before is always prior to that day.
Oh, okay.
Isn't that true?
I see.
In the
I see what you're saying.
Of the world, that always is the case.
I see.
Right?
I see what you're saying now.
You
sir.
do now?
Yes.
Okay, so now I'll ask it again.
Sorry.
Prior to your driving, did you take marijuana?
Yes.
All right. Were you stopped by the police or was there an accident?
There was an accident.
Okay, what happened with reference to the accident?
Between the medication that the doctor gave me and the mixture of low blood sugar, I blacked out while I was driving. And the same thing happened 3 weeks later in another accident. So I stopped taking that medication and I haven't had any blackouts since.
Okay, so my question is what happened with reference to your accident?
I blacked out. I woke up against the wheel, wrecked on the side of the road.
All right.
I just blacked
Were
out.
you taken to the hospital?
Yes, sir.
Was there a blood draw?
Yes, sir. I voluntarily blood draw. Yeah. Yeah. I'm sorry. I'm not trying to make you upset or.
I'm not upset. I just need my
It's just early.
I just need my questions answered.
It's just early and I'm trying to process everything.
There was a blood draw.
Yes, sir.
What were the results of that blood draw?
I cannot tell you. All I can tell you
All right,
is
so stop. Ms. Lundy.
Yes, Your Honor. There was a blood draw. There was no alcohol detected. There were 2 different drug analyses done. The first showed 1.8 nanograms per milliliter of 11-hydroxy delta 9 THC and 3.7 nanograms per milliliter of delta 9 THC. There was also, I think, sertraline, which is Zoloft, that was located as well in the blood. Sertraline, excuse me.
It was, detected but not quantified.
Not quantified.
Got it. All right.
Just an
Sir, do you have any reason to dispute those blood test results?
No, sir.
All right. This is going to be the tough one. Do you believe that on that date, at that time, that you're in gestation because you had THC, or at least the effects or the remnants of THC or marijuana in your system, as well as the other drugs that you've taken, that impaired your ability to operate that motor vehicle?
Yes, sir.
Thank you. Counsel, have I finally complied with the court rule, and would it be proper to accept this defendant's plea?
You both satisfied?
Satisfied, Judge.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed.
I'm sorry, by the way, for
Is
making that so complicated.
it's not complicated for me.
I know, I'm sorry.
Defendant is referred to Von Swartz for an alcohol screening and assessment and the victim's impact panel, as well as a drug assessment.
When it
sentencing will be
May 28th at 12 p.m.
May 28th, 2024, 5. What time? 12 p.m., 12 noon.
Can you repeat that date one more time, sir?
May 28th.
May 28th.
12 noon.
12 noon. Okay.
All right.
That's for sentencing for this case.
Correct.
Okay.
All right.
Yeah.
Thank you.
Thank you.
On your way out, stop down at probation. They'll be on your left-hand side. That way we can get the process started.
Okay.
I'll walk
Sounds
with
good, sir. Thank you.
Thank you.
Your case can also be approached very briefly, just 1 second.
Sure. Hey, that was fun.
Yeah.
So I've done 2 cases. Not calling it. I've done. Those were 2 hard cases. Courthouse case, people, versus Travis Oliver.
Alexander, on behalf of the supervisor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Oliver, who stands to my right. Please state your name for the record, sir.
Travis Oliver.
Thank you.
Thank you, Your Honor. Today's the day and time set for a bench trial. My client and I are ready to proceed.
And the people are ready to proceed as well, Your Honor, and I did want to put on the record that there was an offer extended for the defendant to plead as charged with the prosecutor's deferred, and it's my understanding he's rejecting that offer.
Is that correct?
That is correct, Your Honor.
All right, let's roll.
Thank you, Your Honor.
All right. Go ahead.
Your Honor, people would first call Carolina Elise.
All right, are you waiving
Oh,
open?
waiving opening, sorry, Your Honor.
Any objections to the waiving opening?
No, Your Honor, defense would also waive opening.
All right, very good. Ma'am, come forward and be sworn.
Testimony about the truth, the whole truth, and nothing but the truth, so help you God. See, thanks for your first and last name for the record, please.
Can you spell that, please?
Oh, CAROLINA
L-I. All right, very good. Main court.
Thank you, Your Honor. Good morning. Do you know a Travis Oliver? How do you know him?
We are married, currently separated.
Okay. And if you saw Travis Oliver today, would you recognize him? Is he in the courtroom?
Yes.
Can you briefly identify something he's wearing and where he's sitting?
Right over there, wear black.
Your Honor, please let the record reflect that this witness has made an in-court identification of the defendant.
Without objection, the record shall so reflect.
Thank you, Your Honor. So I'm going to direct your attention to January 20th of 2025. on that date, were you at 4975 Washtenaw Avenue?
Yes.
And is that in Ann Arbor?
I think it's at sea.
Okay. And is that in Washtenaw County?
Yes.
Michigan? Okay. And on that date, did something happen that made you contact police?
Yes.
What happened?
We were exchanging, or my daughter, he was dropping my daughter off to me, and he was upset, and caused a big scene, damage to my car, and then proceeded to follow me, or pretended to follow me to a certain extent. I was scared.
Okay, so let's go back to when you say he damaged your car. How did he damage your car? What happened?
He parked right next to me and opened his door as hard as he could. And his door damaged my passenger front door, dented it, and the paint peeled.
And were there pictures taken of this damage?
Yes.
Your Honor, may I approach the witness of People's Proposed Exhibit 1?
Yes, you may.
Thank you. And what did I just hand you?
It's the picture of the damage.
And that's a fair and accurate representation of the damage to your car caused by Mr. Oliver?
Yes.
Your Honor, the people would move to admit People's Proposed Exhibit 1.
No, Judge.
Exhibit 1 is admitted.
And maybe publish it to the court, Your Honor.
Yes. Just hand that to me. Thank you, ma'am.
Go ahead.
And do you expect this damage to cost money to fix?
I believe so, yeah.
Okay.
Objection, sorry for the later. Your Honor, I would ask to strike the witness's testimony as a speculation.
That it would cost money to fix?
Do you think it will cost money to fix? I would object as a speculation, Your Honor.
I'm not sure even how to deal with that. Objections overruled. Go on.
Thank you, Your Honor. Okay, one moment, Your Honor. And what kind of car do you have?
It's a 2020 Ford Explorer.
Okay. And when he arrived at the location to do the custody exchange, how did you know he was upset?
As soon as he approached, he was shouting from the car. When my daughter was bringing her things in the car, he was just shouting. I could tell that he was upset.
Okay. Can I have one more moment, Your Honor?
You may.
And your vehicle is registered to you?
Yes.
And did you give him permission to hit your vehicle with his car door?
No.
Okay. Nothing further from the people, Your Honor.
Cross-examination.
Thank you, Your Honor.
Morning, Miss Elise. Am I pronouncing your last name correct?
Elise.
Sorry, I apologize for that. My name's Natalie. I'm an attorney for Mr. Oliver. I just have some questions to follow up on your testimony. And to be candid, sometimes I can be kind of a loud mumbler. So if you need me to repeat any of my questions, not a problem at all. So turning directly to January 20th, you testified that you two met at the gas station for a child exchange that night?
Yes.
And this was the BP on Washtenaw Avenue?
Yes.
And it was typical to do child exchanges at this BP, correct?
You said typical?
Typical.
Typical, yes. Yes.
And at that time, you and Travis were separated?
Yes.
And as of today, you have since filed for divorce, is that correct?
Yes.
And prior to the filing for divorce, you were married to Mr. Oliver for about 9 years or so?
Yes.
And at the time of January 20th, there was no sort of court-ordered custody arrangement or anything, correct?
Correct.
Okay. And then turning back to January 20th, you told the police that when he arrived that day, you thought he was already amped up, correct? He was mad about you cheating?
That's what he claimed.
And he was also mad about a trip that you had taken over the holidays with your kids to New York?
He knew about the trip. He was not mad about it. No.
And this was a trip he didn't go on, correct? And he believed you had met up with a guy on that trip?
Not relevant.
Your Honor, this goes to what he was allegedly mad about on the day that she already.
I'll overrule the objection. Go on.
Thank you, Your Honor. So, I don't remember if my question I fully asked or answered, but he believed that you had met up with a guy on that trip.
That incident, no.
Okay. But on January 20th, he was mad at you about perceived cheating.
I don't know why he was upset. He gets mad just because. I have no clue why he was upset.
But did you tell the police on that day that he was mad about perceived cheating?
He was shouting at me that I was cheating with, he stated a random name.
Oh, gotcha.
So, yeah.
Gotcha. I'll move back, or going back to January 20th, sorry. You told the police that during the interaction with Mr. Oliver, you were in your own car this entire time, right?
Correct.
And Mr. Oliver didn't at any point try to open your car door, correct?
No.
And he didn't at any time try to reach into your car in any way?
No.
And you also told the police that on this day, there were no physical assaults by Mr. Oliver of any kind, correct?
Correct.
And you testified today that your property was damaged, the car door.
Yes.
Did you have this damage since repaired?
No, I haven't.
Have you gotten a quote from any professional on how much this repair might cost?
I haven't.
And since January 20th, when you're out and about in your car, going places, have people that you know, have anyone mentioned this perceived damage to the car door to you, or has it been noticed by anyone else?
Yes.
And you testified that it was Mr. Oliver's car door that caused this damage to your car door, correct?
Correct.
And he never threatened verbally that he was going to damage your car at any point, correct?
No.
And this took place at night, correct?
It was evening, like 7-ish, 8.
Was it dark out?
Yes.
And this car door, your testimony was that it only hit you, Mr. Oliver's car door only hit your car door once, correct?
He opened the door, hit it, and then pushed it even more to kind of like that, I guess, just dent it more. So he opened the door hit my car, and then he gave it like another push.
So there is no video of this incident, correct?
There's a video of it, but I don't know that I got the door part.
And
So there's a video of the shouting?
Yes.
Has that been provided to the people?
No.
No further questions, Your Honor.
Is the video available?
Yes, my phone.
Okay, so I think, counsel, that's probably, it looked like a surprise to both parties, but I think that's gonna have some bearing on what exactly was going on. I would suspect that both sides may want to look at that.
Yes, this is the very first time hearing this from anyone, Your Honor.
I think I said that. I think Ms. Zenda had the same surprise, so.
We have not seen this video or.
All right, so do you have your phone with you or?
My purse, yeah.
All right, so why don't we do this? Why don't I take a break and you can show that to prosecutor and to.
Okay.
All right. All right, court's gonna stay.
Like I said, to the
You may be seated. Back on the record in the case of the People versus Travis Oliver. Ma'am, I just remind you simply for the break that you're still under oath. State, you may continue.
Thank you, Your Honor. Hello again. So I believe where we left off was me asking that there was no video of this incident, and then you made us aware that there was a partial video, correct? And you previously testified, and you would agree with me, I have now reviewed the video. You would agree with me that in the video, Mr. Oliver is seen leaving in his own vehicle, correct?
He was backing out. He did not leave.
And in the entirety of the video, he is in his car, correct?
He was out of the car when my daughter was bringing her things into my car.
But you'd agree with me in the video itself. He was in his car the whole time in the video. And you'd agree with me that the video does not at all show him opening anyone else's car door.
Yes.
And the video does not show him opening his own car door at any point.
Right.
And the video doesn't show him closing his own car door at any point, correct?
Correct.
So you'd agree with me that there is no video of his car door hitting your car door. I believe that would be all the questions for me. Thank you very much, ma'am. Thank you, Your Honor.
Can you redirect?
Just a few questions. Why did you feel you had to start recording the interaction with Mr. Oliver?
Because I was not sure what he was going to do next.
And that video, at what part in the events of the 20th did that video occur? Was it the beginning, middle,
That
end?
was right after my daughter got in the car, we closed the door, and I was getting ready to leave. And he just kept on shouting things at me, so I thought, this is going to keep going, so I should record it.
And the video occurred after he hit your car door?
Yes.
Does it? At you in a way that you perceived as being angry?
Yes.
Would counsel agree that's on the video?
I would agree, Your Honor.
I believe she tested or just stated that her opinion was that he was angry at her. I certainly would dispute if that was her feeling. I would definitely take objection to being characterized as Mr. Oliver yelling or screaming at all in the video.
Okay, so is there a reason I'm not seeing the video?
I would have no objection to its admission. I was
would have
not
no
moving
objection.
for its admission, however.
I mean, if you don't want me to see it, I'll just, oh, that's fine. But I mean, part of it seems to me in this is one's motivations for doing what they're doing, so.
So you took a video on this date, and did you provide the video to the prosecutor's office today?
Today.
Today.
Yes. Yes.
And was the video you provided the video we were just discussing?
Yes.
And Your Honor, the people would.
Is there a cable down?
Yes.
If I may, the police officer that came to help, she saw the video from the gas station. She went to the gas station and saw the video, but I don't know what happened to that.
From BP?
Yes.
Is there any indication that that was preserved?
I have not seen the BP gas station video.
Pardon?
I have not seen the BP gas station video, Your Honor. I don't believe that was.
I have not either. I do not believe either party has it. And this is a proper proof to the court and review the body cam video of that office in my review of the body cam video of officer talking to that attendant. I do not believe that that video has ever been turned over.
And it was not mentioned in the report, Your Honor. The video.
Okay. All right.
Is what's on the screen, is that a fair and accurate representation of the video that you provided today?
Yes.
Your Honor, the people would move to admit people's proposed exhibit 2.
No, there's not.
Exhibit 2 is admitted.
Maybe publish to the court, Your Honor.
Yes.
I think my volume. Oh. Your Honor, if I could have one moment.
Pardon?
I have one moment, Your Honor. And I did want to correct the record. There was mention of the BP gas station video, but I do not believe we ever received that video.
And I would agree with Ms. Zenda that I do not believe that the prosecutor's office has ever received that. And I haven't certainly reviewed it. And based on my review of the other discovery, I would not be surprised if the Pittsfield Township Police Department also have never received it either. They tried.
Well, it mentions the video.
Yes, Your Honor, in the report, but we never received a video.
Does it exist?
I don't know.
So-
That's a question.
This might be a little clunky, but frankly, in the review of the body cam video, the officer did speak to the gas station attendant who said, I can submit that to you likely tonight. I don't know if it's gonna be during his shift or after. He said it saves in our system for 7 days. He would have to be sending it to an iPhone, and the video, the body cam ends with the promise that he was going to be sending the video.
To the police.
Yes, so I don't know if they ever received.
No. So why don't we contact the police and find out if they have the video?
I can call the officer.
All right. Why don't we do that? Was there any other questions of this witness? All right. Any questions?
Nothing.
No questions? Okay, you may step down. And while you guys try to figure that out, we'll take a brief break in this and figure if we have the video. Otherwise, I'll just call it on. Is there going to be any more witnesses for the people?
None from the people, Your Honor.
All right, at this point. And I will wait to ask if there are witnesses for the defense until we figure out if the video's there. Okay. All right, so I'll pass on this matter. I'll take care of some other matters and let's figure that out, and then I'll come back to it. Hey. But I don't have,
Yeah, the one we had.
Attorney for Bodman here yet? Oh. Oh, there she is.
All your. The only affirmative case left.
Left.
Yeah.
So no dismissal came in on that.
No, I've received the other 9. This is the only one I have not received yet.
All right. You guys ready? Arbor 1 West and Arbor 1 versus Rico McGuire et al.
Ellis Friedman for the plaintiff.
Henry Anton, the defendant.
Okay.
Randy Barker, city attorney for non-party city of Ypsilanti.
Okay.
And Travis Gagne on behalf of Beal Properties.
All right. Where are we?
Your Honor, you ordered and kind of, we all agreed to have a meeting to try to work on a schedule and a plan and some deadlines and so on for permitting, construction, inspections, et cetera. That meeting took place yesterday at City Hall, and it was, I would say, very productive. Schedules were set forth, agreed upon. Protocols were set forth and agreed upon. We're shooting for, I think it's the 20th. Well, I'm gonna, could I let Ms. Gordon-Leeman do the particulars?
Yeah, she's gonna talk anyway.
Okay. We'll let her start right now.
Yeah.
So yes, it was very productive, good progress made, everybody left the meeting saying the same thing. We went through, I know one of the things we had discussed after hearing.
thought we had resolved kind of came about again last evening in an email exchange, and that involves the testing for the mold in these units. And our resolution, to I guess resolve some of this unpermitted work issues with mold contaminated drywall or wet drywall that need to be replaced. You need a permit for that. Was that they would do the unpermitted work. They would do what's called a scope or a probe type of air quality test, just at very least to satisfy us for purposes of our inspection, purposes of our certification process, that the black mold that seems to have been stigmatizing and permeating these buildings and all the other ones has been remediated effectively. You can't get rid of all of it. We understand that. There's also natural outside molds that are not toxic. We understand that too. But that's what we thought we had going on yesterday is this happening. And that was because of the report that was shared with us by the landlord with recommendations that each unit be evaluated for mold based on the testing, particularly based on testing that showed that the units that didn't have indicia of mold or where it was visible, in some cases are actually testing higher than where we knew where it was. So that seems to be our sticking point that we're trying to work through. And that resolution was in lieu of addressing some of the headaches and the additional costs of tearing out unpermitted work so that we can perform the inspections of the root cause of the mold moisture being resolved. So that's where we're at. I thought yesterday's meeting was incredibly productive. Of course, there was some tumult at the beginning that everybody worked through, which is what happens in these types of meetings. But the fact that you weren't called yesterday, I think should be, something that the court should be fond of. But that seems to be our only issue, and it came up after the fact, after everybody left the room, went home for their day.
And so I will say, response to what Mr. Hartmeer said was, so as a part of the correction orders issued by the city, if they notice mold, that's something that is being remediated as part of the COC reinspection process. So they're following the process of the standards necessary to remediate the mold city noted. That's been done. So when they come back for reinspection, if it said there was mold in this unit, that's been taken care of. As Mr. Barker also indicated, there was some concern about work being done without a permit, so that they weren't able to necessarily verify whether or not there was an issue in that area with mold before the work was done. So, and an abundance of caution to ensure that we're not ripping out work that's already been done, we've agreed to do the limited scope test in that area. So at this point, we're taking care of the mold that you've noted. We're doing the scope test for areas that you have noted there were concerns and there's work without permits. But the city is asking us to do air quality tests in all units, even units that they didn't know mold was in. And so while this didn't initially seem unreasonable, we've learned that information from the county level, from the county health department, that they don't recommend this type of testing because it's unreliable. You can have mold coming in, airborne mold from open window. It can be from, plants. It can be from living conditions. It can be from anything. So you test for air quality mold in all those units. Some you may get some hits, some you may not. So if the goal is seeing if there's mold in these units, we're
well, where is that request? Where is that the city's position that the mold that testing needs to happen?
Well, actually, we're getting a different bit of feedback from the county health department because of the how aggressive the mold was in all of these buildings. And mind you, the reports that were done initially were actually produced by the landlord, except for these two buildings. It's apparently almost.
No, I understand all of that. I guess what I'm getting at is, what is county health recommending? Because I know in other cases that testing, you're right, they don't recommend that testing because it may or may not tell you anything.
It's what you're testing for. Mr. Myers is here. He actually spoke to the health department this morning.
Good morning, Judge. I had a lengthy conversation with Christian Swat. And on the county's website, it does indicate in typical circumstances that indoor air quality isn't recommended. However, with the conditions of these buildings, she would definitely recommend indoor air quality testing due to the nature of the report that was submitted to the city by the landlords, as well as the mold conditions that she has observed on the property. I'm waiting on getting an affidavit from her. They're checking with their legal counsel right now on the condition of mold out at this property as being a concern to the county health department. And so while in very typical average circumstances, it would not be something they would recommend. In this case, that is not the case. And this is not the case in this particular matter.
All right. So I guess then my question would be, if county health says this is recommended, is it going to be done?
I mean, my understanding as well is that if
I guess I'd like to address that.
Yeah.
Air quality testing is inherently unreliable, which it is.
I know.
And there is evidence that there's mold in some of these units and some not. I don't know how the testing becomes more reliable. It doesn't make the testing more reliable. It seems like that it doesn't connect.
I mean, at some point, at least as I'm to understand it, you're right. In a typical circumstance, you're not going to get anything you can necessarily do anything with, because it could be, as counsel, outside. It could be coming from anywhere, right?
Yes.
However, if what they're saying, and having dealt with these cases for a while, that there is some significance or something that occurred there that would indicate some alarm based on this testing, then maybe something else need be done. But again, and I understand your point, Mr. Freeman, that I don't know, you do the air quality testing, it could be because of the building, it could be because of whatever, or it could be something outside that is just exacerbates the problem. But I'm not sure how you're going to know unless you're doing sort of specific testing.
I guess the thought of doing air quality testing on 18 buildings at 24 units seems like that might be overkill, to say the least. And it seems it should be more site specific as opposed to this broad brush.
Quite frankly, I would agree with you, given what I know about the testing. I mean, it just seems to me that you don't.
Well, also the cynic in me, Your Honor, is that the testing is usually done by the company that recommends further testing, and this the conflict is readily apparent.
Right. And the problem, what's going to happen if there are sort of inconsistent results? So you've done the specific testing in the units, and then all of a sudden the air quality says whatever, says something bad.
and that's part of the concern as well. On top of the unreliability of it, we're concerned that we get these results and the city sees them and says, there's something in the air and we got to rip apart all this work to we want to see what's going on. The city has not been shy about cited in these collections, they noted issues where they saw them. And if they noted mold, they submit their reports, and we've been correcting it. We're doing a scope test, and we read that, so I don't know what else we need to do to take care of their concerns. These air quality tests are not going to assist us any further with establishing, is there mold in this apartment? Because it's so unreliable as to where it's coming from. And if the end goal is.
Well, yeah, and I guess that's, and if I put it in the reverse of what I just said, but I kind of was saying it. If the specific testing indicates that the mold has been remediated within certain levels, of course, you're not going to get rid of it all, but then the air quality comes back high, what's the city intending on doing with that?
I think what's gonna happen before I can really answer that question is, we're gonna get those results back. And we're gonna run them by the health department, who gave us a different position than they've given the landlord here. But it's gonna be what did they find? It's gonna be black mold or which I think it's Staphylococcus and a few other ones that are known toxic. That's going to be a problem for us. I think that might actually be a problem for MSHA. So the health department, we don't control MSHA, we don't control the health department, we don't control DHHS, who would have a say in whether they're going to allow these departments.
Okay, but here's the problem. If the mold is of such a level, the health department themselves, if they wanted to, could cite the owners. I mean, it could take their own remedial action. I'm trying to figure out how one would take this testing that's not recommended and use it. I mean, because it can tell you all kinds of things. I mean, but it may not tell you what you necessarily want to know.
Don't need to know.
What?
Or need to know.
Well, you may need to know it, but it may not matter. I mean, hey.
For the purposes of the plan that we discussed and getting us to CFC, I just don't think that this requirement on us at this point from the city is an appropriate requirement to put on us in order to get to CFC. Taking care of the mold they cited, we're correcting this, we're doing the scopes. Like your Honor asked initially, if another issue comes about where there's discussions that their quality testing may be required from some other agencies, that's separate and distinct from what we're dealing with here. But for the purposes of this agreement with the city, we would be fine with moving forward with the remaining portions of our plan and not including this requirement that we must test every single unit in these two buildings. The city's also indicated that they're going to want testing on all of the buildings as well. That just does not seem like a reasonable or a requirement that they would be authorized to make of us right now. So that's where we are.
And we're being told something different by the health department.
Well, I'm going to need something from the health department. So when did they say they were going to have an affidavit?
They had run by their council, I think.
So they have already provided an affidavit to the county. I'm working on getting that one. I can work on getting another affidavit, but my guess is it will probably be Friday.
They've already provided what to an affidavit regarding this air quality? Okay, the mold concerns, but I thought this affidavit specifically was going to address the air quality testing.
So we were told last night at 6 p.m. that they of this. And so I reached out to the health department immediately after. I had a couple of email exchanges. I spoke with Chris this morning, who was heading into a meeting. And then I have not had a chance to figure out what Your Honor would like us to get from the health department. Now that I've heard, I can work on that. I can't.
Well, I thought initially I thought there was going to be an affidavit indicating that despite our indication that this is not recommended testing, they would be going through the specifics of what in this would change that recommendation.
And they have no problem doing that. I just, that affidavit has not been created. There was an affidavit sent about the concerns of mold at this property. And so
yeah, but I can have that at any, I get that people were concerned about it. I don't think that's ever been a secret. I'm talking about this, something from the health department that says we're changing our recommendation, in essence. That now this is something that would be required.
And I could request that of the county health department. They also said that if the judge would like to hear from them directly, they'd be more than happy to speak with you.
Yeah, I don't mind speaking with them, but all right, let's do this. Can somebody send me, if it's agreed upon, at least without this one sticking point, can somebody send to the court, to Ms. Weidling, the synopsis so that I have that?
Synopsis is agreed upon
is that the synopsis is agreed on?
Yes.
That was one of the big sticking points that the city had, was the testing. And so when we found out, we tried to figure out what that meant.
Hold it, let me back up. Because when we first started this, you guys were telling me how productive it was, blah, 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 blah. Well, I didn't mean it that way, but you're telling me all that. At some point, somebody is saying, we have a synopsis of what we agreed upon, but we have this one sticking point.
Sure.
So it would seem to me that absent that one sticking point, there's a synopsis which encompasses a plan of what needs to be done.
Yesterday, we had a meeting, we agreed that our side would prepare the summary. We provided it to the city, in addition to our comment regarding the air quality, indicated provide us with your edits and thoughts. We have not heard anything back. Obviously.
We had a conversation this morning.
Oh, yeah, we talked this morning verbally about this air quality issue. We have received no other comments or concerns about the remaining portion of the summary that we prepared. I have not seen anything from the city with regard.
So does the city have objection to the synopsis?
Generally, no, but
I don't know what that means.
well, hold on, let me put to it. So if the agreement was that, we'll use the ICC book to, but, when talking about permits, we'll use the ICC book to address any severe understatements of value for purposes of the permits, adjust the permit value appropriately. That was agreed. That's what the synopsis also includes. If we had some other procedural matters with our BSNA software, I think we're looking into that. Having a regular meeting where appropriate, we had that agreement. Single avenues of contact versus revolving doors of people, we have that agreement because I observed a nice breakdown of communication that might have led to a lot of this. But then we have this remaining issue of the air quality testing was.
I don't want to deal with that right this second.
Sure.
I thought there was a synopsis that everybody had agreed on, and that this air quality then became a sticking point, which then started to involve the health department. So I thought, based upon what I heard, that prior to even me calling or talking to anybody at the health department, getting an affidavit or anything, I could at least see what the parties have agreed on. But now I'm hearing that the parties didn't agree on that.
We agree on everything except the manner in which the air quality testing and mold testing is going to be done, because we agreed to have that. It was our understanding at the end of the day yesterday before the end of the day yesterday, that would be done in lieu of requiring tear out of the illegal and unpermitted work.
The scopes.
Is there any objection to me sending Your Honor the summary that I provided you yesterday with the removal of that one portion regarding air quality? Okay.
Wouldn't be for me.
Okay, so if that's the case, then we have a summary of everything we discussed yesterday in our, this was provided to the city yesterday. And we can provide that to, I can simply remove the one line that we was in there about air quality testing with the understanding that the remaining portion in there is all what we agreed on and discussed yesterday. That would be.
Except to the extent air quality testing was used in lieu of tear out of the unpermitted work so we can inspect it. That's exactly that's what the sticking point is. I think everything else is.
But I thought, hold on.
The scope is not the issue. We're talking about.
Yeah, but I mean, I'm talking two different types of testing here, because there's the scope testing. I thought that was agreed upon, and maybe I'm hearing things, that was agreed upon in lieu of tear out.
Correct.
But that then there was this added thing of the air quality, where the parties didn't agree because the county on the website says, or has said in the past, that is not recommended, but now is supposedly preparing something that says it is recommended. But I thought up to that point, everything was agreed upon.
You're right.
I know, but so now the air quality testing, again, folks, correct me if I'm wrong, just seems to be this other thing out there that somebody's recommending. To what end, I'm not sure yet, but that somebody else is recommending. But in terms of what's going to happen, the parties agreed on that.
Correct. And I'm going to say when we walked out of the room yesterday, we had agreement on the air quality testing, in particular because of their reports recommending that. But that seems to have been something they reconsidered at the end of the day. So that's the one sticking point. They were worried about the cost and the necessity and the benefit. And I understand that.
In any event, Your Honor, we're prepared to forward the synopsis to you right now. And we're prepared to go forward with it right now, just commencing today. And then as to one other and very important matter, we did have the escrow money has been wired to us to be placed in the court's escrow. 62,000.
Is that the envelope? Yes. You know, I could like smell money. So I knew that's what it had to be. So I didn't really worry about it because I said there's an envelope, it's got money. I just knew it. Well, I can't take money, but it will be paid up there. And so that you know, we were trying to figure out how we were gonna hold it. We will be holding it on Mr. McGuire's case, but it will be noted as to what it is so that it's not whatever, but we'll know where it is. Okay, is that? What, do you just point to the ceiling going, shouldn't you like take me out or something? That was what, aren't you supposed to? I'm good. I'm safe, Alan.
The rest of us are.
Yeah, but we're not worried about that. That's not Alan's job. He just points at the ceiling.
Are they doing mold testing up there?
I don't know what you're okay with it? No. I sometimes would like for you to show a little more alarm. Even if it's false, I just need, like that there's some urgency. That's okay. I'm good. I'm good. If you tell me I'm good, I'm good. Okay, so we got that part. That's coming into me. And Okay, let me do this. Is it already over? Do me- Oh. Everything goes to Ann. That's okay, he's got it, because. We don't have it?
We have. But neither side is going to.
The BP video you have, but
Yes.
neither side wants me to see it. That's okay, that's fine. Okay, so that will come over.
I believe Mr. Beal is already.
All right, so folks, let me ask this. And I'm gonna take a break and go look at, I want to take a look at the synopsis, but while we await what the county is going to say about this air quality test, can things move forward?
Absolutely.
Yeah, we felt after yesterday, we see the finish line.
Yep, we've got target dates.
So
we're ready to roll.
Theoretically, just so that there's no surprise, county comes and county says air quality testing is not necessary if these other things are done that are being done. Then is everybody on the city side and everything, are you gonna be good with that? Pardon?
So we have received a letter from Ms. Gorman's firm saying that Jerry Dunn is not welcome on the property and they will call the police.
Who is Jerry Dunn?
He is the building official for the city. And
so why am I dealing with that right this second?
Because they have asked Jerry Dunham to come do inspections on the property.
I guess there's a sticking point. Mr. Beal has no concerns with Mr. Dunn being on the property. The owner has expressed it, and that's how we're gonna make sure.
Was I just talking French? I thought I was talking about air quality.
Oh, I understand. That was the only other issue that Mr. Myers had addressed that.
We've talked about the fact that we want him to do inspections, Your Honor. That's just, come on.
That's for a different time.
No, folks. Okay, so let me deal with the issue I was dealing with before that other thing gets thrown in. If the county comes in and says this air quality testing is not necessary, is that going to be satisfactory for the city?
I don't know how it would be an impediment for us. Okay.
If the county comes in and says this air quality testing needs to be done, are the owners, number one, willing to go forth with that air quality testing?
Just one second.
So I think a part of our concern is that if they come and give an opinion, they're not considering the work that is currently being done to remediate all of any mold that has been cited by the city. They're not taking into account the scope tests we're going to do that may determine. So the health department is giving an opinion on what?
No, I know. And so certainly for either side, when the opinion comes, there's going to be this notion of what are you basing that opinion on, right? So I get that, but
it sounds to me like the health department would be saying, hey, we know that this property has previously had issues with mold. We are going to recommend or not recommend this. And our position is we're taking care of those problems. So even if they come and recommend it to us, if our response is you're taking care of all the problems cited by the city, what is this recommendation based on? And is there also, is there a legal requirement that you do this?
I think we can't give you an unqualified yes to that question.
Oh, I was getting that very clearly because anytime the attorney from Bodman just starts talking, it's not going to be it's going to be qualified. Okay. What I'm a little bit worried about is, and why I need to take a look at it is, how is work going to proceed if it might have to be redone because of this air quality thing? That's what worries me.
Well, we're of the opinion that there's so much on the list that needs to be done that we
can go ahead.
We can move ahead.
Okay.
Yes.
Would you agree with that? Okay. So what's this issue with the inspector? Not that I want to get there, but
it's no longer an issue. He was there all the time and he was interfering, but we're past that point. He's got to be there to do inspections. We have to have him there.
Okay.
It's a non-issue.
Anything else? All right. So everybody sit tight. I'm going to go back and I'm going to go look at this synopsis, see if I have any questions. And then I'm likely going to give you a new date to come back and at least report. We're looking, our target right now is the 20th, correct?
Yes.
I think what we did, just to have some backups too, is we targeted the 19th, 20th for those final out inspections. And then we kept the 22nd as an alternate date, just in case we have to come back. If you saw something, we have to do a follow-up inspection. Or if there's a problem, we just use the 22nd. So we tried yesterday to create some flexibility in scheduling that.
Got it. I got it. Okay. All right. Court of standing brief.
I won't be back. I won't be back.
Okay. No, I understand. All right. Thank you.
14A District Court of the County of Washington, State of Michigan, is now back in session. The Honorable Judge Simpson presides.
You may be seated. Okay, on the Harbor One West matters, all counsel is present. Okay, I've looked through this synopsis and look at it as being something that certainly workable, and I appreciate the parties going through and doing all of this because I think it at least begins to head in the right direction. We're anticipating something from the health department at some point, but it would seem to me in looking at this, and I would agree with the parties, that progress or things can start to be done and then deal with air quality and mold at some point. Hoping that it's not going to be a circumstance of sort of undoing work that's already done, but that's what I don't want to get to. So what I would like to do, folks, is set, let me just say this, and I kind of explained it to both parties. I think that this can be done. These units can get back online. And so I plan on keeping people on a tight, short leash. So Monday, May 12th at 9 a.m. Will that work for folks to come back? And so I can get a status update as to where we are. That'd be kind of that halfway mark. Give you time to get things going. And I would say that if there becomes a problem interim part, other than the point at which I'm at a judges conference the end of next week. Certainly you can call my office and we can, even if we have to set up a Zoom to try to deal with some of the issues, we can do that.
I mean, for me, the 12th works, pending a telephone call with a circuit judge in Wayne County, that should solve my 12th problem. Available for you.
Okay.
Recognizing the court has unlimited time.
Yes.
We do have, we do have that health department official available for a quick phone call if the court wants to hear from her today. Or
well, have you spoken with anybody on this side? Spoken with? Okay, so yeah, I'm a bit hesitant until each side gets to hear from them. Then certainly I'd hear from them. But you know, not saying anybody did anything untoward, but I'm not sure how the questions and other things were posed that may have led to certain responses. So I want to make sure each side has a fair opportunity to talk with the individual in their own way before bringing it to me. So, but that the individual, did they indicate that they're likely to, that this affidavit is on its way at some point? Right. So I would suggest if that affidavit gets there, that it be shared with the other side and also sent to the court so I can at least review it and see. And okay.
And just to be clear, the tenants aren't expected to be here on May 12th?
No, they are not. They are not.
I'm sorry, you said 10 a.m.
I think I said 9.
You said 9, okay.
All right, folks, is there anything else? Good. I was trying to wait for a response, but not. I was just going to call it and say, everybody have a great weekend. All right. Thank you. And it's Anne. I know she's listening. Anne. Actually, you know what? I don't even have to say anything. Telepathically, she's here. Can we make sure they have the check? Can we make sure that can you go down with them and just make sure that's all done correctly? All right, appreciate it. So she'll help you take care of the escrow.
Is there just one last question? I'm so sorry.
No, it's okay.
Is there gonna be any sort of order entered about anything that we provided to the court, or is this all we're just working under?
I'm not gonna provide an order unless you want one, but I don't think at this point that it's necessary. I may issue an order come the 12th if, depending on where things are, but I prefer to let this kind of work through. And part of the reason is I realize we're sort of fluctuating on certain things and that things have to go. So, all right. Thank you. That's yeah.
Was I supposed to give this to you or?
No.
At the clerk's office? Okay.
Yeah. She's been trying to give everybody that money.
I don't want to.
Yeah, I know. I'm like, I don't know.
Too much money.
And where is Miss Pate? Oh, there she is over there. All right, we'll go back on the record in the case of People State of Michigan versus Oliver.
Ally's on behalf of the people, Your Honor. Assistant Public Defender Natalie Pate with and on behalf of Mr. Oliver, who is now approaching again. Please state your name for the record, sir.
Thank you.
Your Honor, may we briefly approach?
You may.
All rise. 14A District Court for County of Washington, State of Michigan, now back in session, the Honorable Judge Simpson, presiding.
You may be seated. Kyler.
Mr. Kyler's in senior.
Yes, right now. Court does call the case of People versus Elijah Kyler.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Kyler. Mr. Kyler, can you please state your name for the record?
Mr. Kyler, can you hear us? I don't think he can. I don't know if it's something on his end or not. Mr. Kyler?
No, I can't.
Can you hear me, sir? No, he's not here.
No, I can't hear you.
Okay. All right, hold. Do you have the ability to change anything on your audio or to log off and log back in?
Is that better?
I can hear you.
I can hear myself in these, but I can't.
I can hear you, Mr. Kyler, but apparently you can't hear us.
Okay.
Can you type in that?
Okay,
Hey, we can hear them, but
back in.
let me make sure it's not something. Mr. Pinkston, can you hear me, sir?
Yes, I can.
Okay, thank you. I was just testing, making sure it wasn't coming from our end. with
I think
Mr.
it's just
Kingston.
him.
All right, thank you, sir. Yeah. They're signing in. Oh, they're re-signing in. They're re-signing in, Mr. Ernie. Okay. All right, Mr. Kyler, can you hear me now?
Oh, beautiful. Still can't hear it.
Mr. Kyler? No, he's.
Seems like those headphones are not.
I'm almost gonna think it's his headphones, but.
No, I can't hear them. I can hear myself though.
Can you hear me, Mr. Kyler?
No.
No. All right. Let him know I'm gonna pass it. What?
Zoom has settings on the program that you have to individualize both for microphone and headset. I think he's got one and not the other.
Okay, there they go. Yeah, I can hear you now.
Can you hear me now?
Yeah, yes, I can, Your Honor.
Ah.
So it wasn't what Simon said.
No, I didn't.
No, that's not what it was. It wasn't. It's, you just do that so you can wear those headphones that you wear. Although my staff, when you wear them, thinks that you're cute, but I say no.
Thank you, Your Honor.
All right.
I appreciate Mr. Simon's help.
All right, go ahead, Ms. Barrett.
Your Honor, we're here for sentencing. We did review the pre-sentence report and don't have any material to review the deletions. We do ask that you adopt probation's recommendation.
All right, Mr. Kyler, is there anything you want to tell the court before I impose sentence?
No, Your Honor.
Okay. $125 statutory fee, 180 days in jail, credit 180 days served. All right, sir. And
Thank
you're
you,
all
Your Honor.
set.
All
Okay.
right, thank you, Your Honor. Have a great afternoon.
All right. Take care of yourself.
Bye.
Court calls the case People versus Diamond Edmonds. Two cases.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Ms. Edmonds. Ms. Edmonds, please state your name for the record. Diamond me, isolated. You know, I believe we're here on these cases for show causes. So Ms. Edmonds has a balance on both. As the court knows, she's in custody being held on other matters. I just asked for an adjournment of the show cause as I don't believe she's able to make payments right now.
We have a July date. Yeah, we'll adjourn these matters to July 9th, 2025, 9 a.m. or as you're invited to case.
Thank you, Your Honor.
All right, thank you.
Your Honor, may I ask, does she have personal bonds on these cases? Oh, you do? Yeah, so you will be able to.
Yes, that one's a PR. She does not on 1828.
I'd ask for a personal bond, Your Honor.
That's fine. I'll give her a personal. Personal recognizance, $5,000 bond.
Thank you.
Thank you. Case People versus Stephen Burnell.
Edward Drucas for Stephen Burnell. I believe he is on Zoom.
Burnell? Burnell? Mr. Bernal? I think that's him. It's just gonna be one of those days. If that's him, he's not paying any attention. Mr. Shopping. What is that he's buying? Huh? All right. I don't know if that's him or
I'm calling him now, so
you're trying to call him.
seeing if he's gonna pick up the phone on Zoom.
4.
You might. He's going down the sporting goods aisle now. No, I don't know that. Is that your client?
You know, it's hard to see. My eyes are terrible.
Mr. Bernal? Okay.
We could pass it, and I'm sure
Yeah.
this person's gonna pay for their merchandise and
got to get to the checkout. Court calls the case People versus Michael Kyle.
Good afternoon, Assistant Public Defender Lauren Kearney on behalf of Mr. Kyle. Mr. Kyle, please state your name for the record.
Michael Kyle. Thank you.
Your Honor, again, we're here for a show cause on an old case. Mr. Kyle has a balance of $360 on this case. I'd ask for an adjournment as he is in custody.
Okay, how long is he expected to be in for a while?
He's asking if the court would waive the balance. He's been in custody for 10 months. Do you know when you're gonna get out?
Around beginning of June 1st or June 8th, one of the two.
Beginning of June, he thinks he's gonna get out.
During this to July 9th, 2025.
I'm not allowed to watch.
Okay.
Well, you can come back for court and we can get you on Zoom.
I'm be all the way in California.
Okay, we'll get you on Zoom.
All right.
Thank you. He's not allowed back in the county, Your Honor.
What?
He's not allowed back in the county.
He's not?
So, but we'll get him on Zoom if that's okay with your honor.
Not allowed back. Is that a thing? Court calls the case, People versus Salvador Barrentes.
Ready, Your Honor.
Your Honor, Joe Simon on behalf of Mr. Barrientos. State your name, sir.
Salvador Barrientos Jr., Your Honor.
Your Honor, we're here for sentencing. We asked the court to adopt the recommendation. I've explained to my client that if he complies, he may be eligible for release at the halfway mark. Mr. Barrientos is prepared not only to make his fines and cost payment in full, but also the restitution he agreed to pay.
Today?
Yes.
Okay. Sir, anything you want to say before I impose sentence?
Just my deepest apologies to the court and all the parties involved, Your Honor. And I've done my best to comply with everything that the court has asked.
Court does acknowledge this is not a serious misdemeanor as defined by statute, however, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of early intervention program and monitored abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance with recommended treatment. Therefore, the sentence of the court that you're placed on probation for a period of 6 months. You're to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $180 probation oversight fees. That is to be paid today. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You have completed, and I will order that you complete the alcohol awareness program. You are to provide proof of the victim's impact panel attendance to probation. That has also been completed. I'll continue to sober link for a period of 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, the balance is suspended.
Patricia Blair on behalf of probation, Your Honor, with the label that I provided to the court, I did miss the restitution on your label.
Yes.
That restitution amount is $1,425.
Hang on, $1,425.
I think it was 75, wasn't it? 1,475.
I thought it was 25, but
Okay, then that's a typo on ours. Yes, 25, thank you.
It was 25,000.
No.
What?
No, you're
So restitution is $1,425.
Correct.
Restitution in the amount of $1,425. That's and that can also be paid today, sir.
that's right, Your Honor.
All right. I'll order that also.
Thank you.
All right. Thank you. Court calls case People versus Gary Thomas.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Thomas. Mr. Thomas, please state your name for the record.
Gary Thomas.
We're also here for a show cause. I don't remember Mr. Thomas's balance off the top of my head. He's been in custody for, I think, 184 days at this point. And has not been able to make payments.
When is he expected to?
Do you know when you're gonna be released?
No.
Doesn't know, unfortunately.
Not, well, tomorrow, it could be tomorrow, it could be 2 weeks.
What I'll do, you need to start, because we agreed back in March of 2024, 150 per month. But what I'll do is I'll adjourn this to July 9th, 2025 night. Right. Court calls case People versus Kesha Bush.
afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Bush. Ms. Bush, please state your name for the record.
Kesha Bush.
Dinner today is the date and time set for sentencing. We did review the pre-sentence investigation report and do not have any material changes, I think. I'm sorry, if the court can just give me.
No, that's fine.
I just want to double check. Okay, no changes. We ask that you adopt probation's recommendation.
All right. Ms. Bush, anything you want to tell the court before I impose sentence?
No, Your Honor.
All right. Sentence of the court, 4 months prosecutor deferred sentence. You're to pay $480 fines and court costs, $120 probation oversight fees. When can you pay that?
I can pay 50 today and then over the next couple weeks, make a payment plan and finish it off before probation ends.
Well, what I'll do is I'll order $50 today and then the balance as directed by probation.
Okay. I'll be sure to make sure to get it all paid off as soon as possible, Your Honor.
All righty. Thank you. There's
I
to be no
appreciate
use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours.
Your Honor, I can't hear you.
Can you hear me now, ma'am?
Yes, I can. Yes.
All right. Where did
You
drop? Pardon?
Sorry, what were you going to say, Your Honor?
Okay, I know we got through the cost. There, did you, well, I'll just start from number 4 on. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 60 days. You're to complete 25 hours of community service as directed by probation. No going to any Walmart store in the state of Michigan. I will set a review hearing. That's to be held August 27, 2025 at 12 p.m. I'll order 90 days in jail that is suspended.
Okay.
All right.
Thank you, Your Honor.
Calls case, People versus Jordan Hartmeer.
Good afternoon, the Public Defender Lauren Perny, Mr. Hartmeer. Mr. Hartmeer, please state your name for the record.
Jordan Hartmeer.
He didn't go to his pre-sentence appointment.
Yes, Tracy Clare on behalf of probation. Your Honor, Mr. Hartmeer did have a PSI appointment with my office on April 10th at 1 p.m. He failed to complete that appointment. Given that Mr. Hartmeer is before the court for the first time for sentencing, at this time probation is asking for a re-referral to probation to complete the PSI, that he pay a $75 re-referral fee today with a new PSI appointment on May 6th, 2025 at 1 p.m. I would ask that the court order him to appear for that in person and adjourn his sentence date to May 14th, 2025 at 9 a.m.
We have no objections to that. When I discussed this with Mr. Hartmeer, he said he may not have the $75 today, but that he could eventually pay it. Mr. Hartmeer, could you pay that today?
I'm currently looking for employment. I've had a couple interviews in the past few days. I'm not positive if I can know.
I will refer the defendant to probation for a pre-sentence investigation and report. You're to pay a $75 referral fee. You're to pay that by May 13, 2025. I'll set a pre-sentence investigation appointment for May 6, 2025 at 1 p.m. That will be in person. Okay. I'll adjourn his sentencing to May 14, 2025, 9 a.m. Thank you.
Thank you.
Court calls case People versus Donald McKenzie.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. McKenzie. Mr. McKenzie, please state your name for the record.
Donald McKenzie.
All right, he is item 13.
Today's the date and time set for Wednesday. We did review the pre-sentence investigation report as well as the recommendation, and we asked that you adopt it. With one exception, Mr. McKenzie is requesting to pay restitution using a money order.
Can't be paid that way.
So it has to be paid in person.
In cash. All right.
Well, Mr. McKenzie, if you have any questions about that, we can give you a call and we'll discuss that in more detail, okay?
Yep, I understand.
All right, Mr. McKenzie, anything you want to tell me before I impose sentence?
No, Your Honor.
To send to the court, you pay $655 fines and costs, $1,399.61 restitution to Enterprise Rent-A-Car payable through the court. When can you get that paid, sir?
Yes, I spoke to Miss Natalie and Miss Teresa. I talked to them about a payment plan of about $350 per month for the next 4 months.
I'll order $350 per month. When are you going to begin that?
I was informed that I wasn't sure if I would be able to decide that as far as the date. But obviously, for my work schedule and everything later in the month, it'll be greater for me, Your Honor.
And Teresa Claire on behalf of probation. Your Honor, it was my understanding that Mr. McKenzie at least had $655 today. Is that still true, Mr. McKenzie?
Yes, it is. That's going to probation fines and costs.
$655 today, $350 per month. That will begin May 30th, and then each month thereafter. I'll order 365 days in jail. Credit 1, the balance is suspended. Thank you.
Thank you, Your Honor.
Court calls case People versus Nicole Nelson. 2 cases.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Nelson. Mr. Nelson, please state your name for the record.
Nicole Nelson. We have no response.
Your Honor, I did speak with him. I don't have an explanation for this desire to appear. I do know he's up north in Gaylord. He just 3 months ago wrapped up treatment at Bear River, was in a transitional housing in Gaylord, and is now working with organization up there that helped him found his own housing. I did provide him with the Zoom information. I'm not sure why he's not here.
Teresa Claire on behalf of probation. Your Honor, given that Mr. Nelson failed to complete his pre-sentence interview appointment and he's not present today, probation is requesting a bench warrant for release.
Bench warrant for defendant's failure to appear on $5,000. I'll give a 10% privilege on that. Those warrants will issue immediately. Calls case People versus Robin Nobles.
Good morning, Assistant Public Defender. Afternoon, Assistant Public Defender Lauren Perry on behalf of Ms. Nobles. Is Ms. Nobles on Zoom, Your Honor?
Robin Nobles. Nope.
Well, I have no explanation for a failure to appear today, Your Honor. For the record, I'd request an adjournment.
Pretty clear on behalf of probation. Your Honor, Ms. Nobles did fail to complete her pre-sentence interview appointment with me. I also know that she has a felony warrant for failing to appear. I believe it's for given that she's not present, failed to complete her PSI probation's recommendation. That's for issue.
Bench warrant will issue for defendant's failure to appear, bond 5,000. 10%. Warrant will issue immediately. Court calls case People versus Joseph Pinkston.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Pinkston. Mr. Pinkston, please state your name for the record.
Joseph Pinkston.
Your Honor, today is the date and time set for sentencing. We have no material changes to the pre-sentence report, and we ask that you adopt probation's recommendation.
All right, Mr. Pinkston, anything you want to say before I impose sentence?
No, sir.
All orders statutory minimum, $125 statutory fees, 72 days in jail, credit 72, sir. And you're all set, sir.
All right, thank you.
Thank you. Take care.
You too.
Court calls case People versus Cameron Reeves.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Reeves. Mr. Reeves, I'm not sure if he's here, Your Honor. He is in custody at Wayne County. Ms. Pate confirmed that on Vine Link, as well as speaking to his family member. He thought that they were going to be here, but Wayne County is Wayne County.
I'll indicate defendant in Wayne County Jail. I'll adjourn this out to
May 14th at 9 a.m.
May 14th, 2025, 9 a.m. Well, that's not going to be enough time. Need the next one.
The 28th.
May 28th at noon. Case of People versus Matthew Brown.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Brown. Mr. Brown, please state your name for the record.
Matthew Brown.
Today's the date and time set for sentencing. I apologize, Mr.
Set for sentencing?
I'm sorry, it's set for a show cause.
Yes.
I apologize, Mr. Brown, if you spoke to an attorney. I don't have notes on the case. So I'd ask Mr. Brown if there's an amount that you can pay on this case moving forward.
Yes. Can I make a like a $40 payment today, and I can make another payment when I get paid, and then I'll get on a payment plan? I'm on a payment plan with two other court.
So you can pay $40 today, and then how much can you pay next time you get paid? When is that? When's the next time you get paid?
I can't hear anything.
I didn't hear you, sir.
Hello?
Hello? When's the next time you get paid?
Okay, I'm sorry. Is it fixed now? There we are. I'm sorry about that.
Brown, the judge asked when the next time you get paid is.
I get paid every Friday.
All right, and how much can you pay every Friday?
And I mean, I have 4 kids. Is there any way I can make it like every 2 weeks or something like that?
Okay, how much can you pay every 2 weeks?
Like $50.
All right, then $50 every 2 weeks. And we'll begin that May 16th.
Okay.
Okay. All right. Thank
Okay.
you.
Thank you.
Calls case of people versus Belarus Cook.
Good afternoon, this is Public Defender Mark Henry on behalf of Ms. Cook. I does not have any contact with Ms. Cook. I'm not sure if the contact information we have is still accurate. I request an adjournment for the.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. Give a 10% privilege. That warrant will issue immediately to go along with their other warrants. Court calls case of the people versus Daquan. Is it Delani?
Hello.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Daquan Delane.
Delane.
Yes.
We're here for a show cause. He, when I spoke to him about this, he just got back to work. He believes he can pay between $50 and $100 per month, beginning this Thursday.
How much can he pay?
He told me between $50 and $100 a month, beginning this Thursday.
Is that right, sir? So you can pay $100 per month?